We will be hearing two bills today. The first is House Bill 2681. And I'll ask the reviser to brief us on that bill.
All right. Thank you, Mr. Chairman. Jason Thompson, Revisor's Office. House Bill 2681 establishes the Department of Corrections Peer Support Fund and transfers certain monies from the State General Fund to that new fund. Section 1 is the new section of law that's created here, establishing a Department of Corrections Peer Support Fund to be administered by the Secretary of Corrections. It also provides that on July 1st of 2026, or as soon thereafter as monies are available, the Director of Accounts and Reports will transfer $500,000 from SGF, the State General Fund, to the Department of Corrections Peer Support Fund. And then in future fiscal years, the fund would receive transfers and other revenues as specified by appropriation acts. So there's a one-time transfer in the bill and then the option for future funds just subject to appropriation acts. The new fund shall be used exclusively for the department's peer support program for corrections officers and other department employees. Other expenditures from the fund may include, but not be limited to, training of peer support team members, program materials, equipment, travel expenses, staffing costs associated with the peer support program, and other expenses as may be necessary to implement and operate the peer support services. The services funded by this section shall promote mental health, wellness, crisis intervention, and suicide prevention among Department of Corrections employees. And the Secretary of Corrections will be required to submit a report to the governor and to the legislature on or before January 15th of each year, detailing the expenditures and the effectiveness of these peer support programs. It would take effect on July 1st if adopted, and I'll be happy to answer questions.
Thank you, Jason. Are there any questions from committee for the reviser? Seeing none, we'll move on to proponent testimony. I believe we have Tyler Weingartner in the audience. Mr. Weingarten, welcome to the committee. I know this is your first time to testify. You told me that yesterday. Is that right?
Yep.
Well, we're pretty casual here. And you have your microphone on now. Try that.
Hello.
Yeah, okay.
My name is Tyler Weingartner. I first want to reiterate I am not an official representative of the state. Everything I do on my personal time from home. I'm here to bring awareness and support to a problem most people don't think about, and that's the hidden toll to being a corrections officer has on people. I'm a sergeant with the Ellsworth Correctional Facility as a member of the KDOC Peer Support Team and the Special Operations Response Team. Being on SORT means I get to travel to other facilities, talk to officers from other facilities. SORT gets sent into other facilities when things are at their worst, high stress, low support, and chaotic surroundings. I've seen brothers and sisters in this line of work turned into shells of themselves, hollowed out by the chronic grind we face every day. Today, I will share a few stories of what I've seen. On June 25th, 2025, a resident consumed mind-altering drugs, during which he was claiming demons and the devil were after him. As I called to code to get more officers to the scene, it escalated into violence. I and other officers were battered while trying to gain control and securing him. The night wasn't isolated. It's emblematic of the job's unyielding and constant vigilance. Moral injury and psychological wear that compounds fast. Another situation happened on September 3rd, 2025. As I was running the living unit, it's supposed to be pretty routine on night shift, 5 counts, 30-minute rounds in between, and make sure everything's squared away for the next day. That night, it turned into chaos. During my first count, a resident decided he wanted to consume a mind-altering substance. As I called for more officers to come to my location and assist to helping the resident, we got that situation taken care of, at which we had another resident, 2 more residents, same cell, decided they wanted to consume mind-altering drugs. One resident required 5 Narcan As I'm watching this resident slip in and out of consciousness, all I can think to is, why am I here? What am I doing? What did I get myself into? Then I continue to drag on with 2 more altered state, as night shift were already running on a skeleton crew. So officers get pulled away from the areas they are stationed at to help. Now I'm overseeing all of those situations, making sure everything gets squared away correctly. During this, an officer pulls me to the side and says that he can't handle it and he's at his breaking point. This happens very often. I can tell you the amount of times officers come up to me and tell me they just can't handle it anymore. The stats of being a corrections officer are not pretty. Corrections officers have a suicide rate 39% higher than working age population. Some reports put it at 105 per 100,000. That's 7 times higher than the national average. PTSD hits corrections officers 27 to 34% above civilians, even matching or beating military vets. The divorce rates are high as well, with studies showing rates as high as 70% in some states compared to the national average of around 50%. The life expectancy of a corrections officer is at 59 years. That's 16 years shorter than the average of 75. Reports state corrections officers pass away 18 months to 5 years post-retirement. In Kansas, the KDOC has vacancies at 11%, with turnover historically at 20 to 30%. That chronic understaffing, it burns officers out even faster. That's why it's in my opinion that peer support is crucial. We have an existing team of peer support at about 70 members from all across the state, offering confidential help on trauma, burnout, wellness, with annual training retreats when we can find them in the budget. But 1 day of training every few years or sporadic training when we can find it in the budget is just not enough. If we invest over $500,000 annually into expanding training, more coordinators and resources, we can handle the challenges better. Other states like California has over 1,000 volunteers, and it reduces burnout, boosts morale, and cuts turnover. Washington State has seen 10 to 15 better retention with high stress roles. The National Institute of Corrections backs programs in about 12 states, and they drop burnout by 20 to 30%, improving resilience. Research shows peer support slashes emotional exhaustion, hikes job satisfaction by 15 to 20%, and correlates to 5 to 15% higher retention overall. Fiscally, this bill makes sense. The KDOC personal costs are about $207 to $272 million yearly. With 5 to 10% retention gains, we could avoid approximately 50 to 100 turnovers a year, saving the state $1.5 to $5 million a year. This bill creates a dedicated fund appropriating $500,000 from the general fund starting fiscal year 2027. For our peer support team needs training, materials, and staffing. It's a modest investment that'll save lives, keep families together, retain good officers, and make our facilities safer. Thank you.
Thank you, Mr. Weingartner. Any questions from the committee? Yes, Representative Ressman.
Thank you, Mr. Chair. Tyler, thanks for being here today. So currently there is a peer support group. It's just not funded. Is that what it is?
Right.
Okay. And you said that there were 17 members throughout the state that
Yeah, approximately 70 from everything I can find doing my research. There's about 70 members.
That's 70. That's 70 or 17?
Yeah, 70.
Oh, 70. And how is that organized?
So we have a wellness manager, and she oversees the peer support team as well. And she'll do the trainings. I think she does about 2 trainings a year, orientation, where you get trained on being a peer support member. And then when we can find it in the budget, it's authorized by the Secretary of Corrections to put on a retreat for further training. But it's when we can find it in the budget from everything I've been able to find.
Okay, I just have one more question. Yes. And you said what was the divorce rate for correctional officers? I think you said.
And refer to what?
I think you said 70%. Is that right? Or maybe I got my numbers mixed.
Oh, the divorce rates are 70% in some states.
Okay. Okay. Thank you.
Representative Mosley.
Thank you, Mr. Chairman. I just wanted to say thank you for coming out here and talking about mental health. I think that's a really big deal, and I know that this is probably a male-dominated career field, so it's really hard to get to the point where recognizing that you all need help, and so thank you for being part of this cause.
Representative Neely.
I wanted to thank you too and everything, being a former correctional officer, and we have another one over there on that end. But I have a question. Are there individuals in each facility, like this Hutch, Lansing, everybody have one? Or is it that there's more in one spot than another, or?
Yeah, it's all, if you choose to be a peer support member, you volunteer for it and you go through the training, and we have a few in every facility, as well as parole has some as well. So it's not just in the prison system, the post-release also has peer support members.
Okay. Thank you.
I have a question. So the essence of the bill, as I understand it, is to provide some dedicated funding, right? And currently that doesn't exist. You get funding from time to time, but it's not dedicated.
Correct.
Right, yeah, okay. And the bill proposes $500,000 from the State General Fund beginning in the fiscal year 2027. Any particular reason you picked 500,000 rather than some other number?
Yeah, I didn't want to get greedy. I wanted it to pass easy. I want this to get through and pass and for it to happen. So I didn't want to ask for $1 million or $2 million and make it harder to pass. So $500,000 is more than what we have now.
And what kind of things do you think it would be spent on particularly?
So more training, of course, and if it were up to me, hiring psychologists and neuroscientists to come out and study the life of being a corrections officer so we can get a lot more newer stats. Correctional Oasis does a lot of corrections officer outreach, and they say a majority of the studies we have are 10 to 15 years old. So if we could afford it, getting a new study done here in the state of Kansas, targeted specifically, I think would be great.
Representative Schlingensieben.
We've done something similar at the Topeka Police Department, and I know that sort of in the early iterations of the program, it was very hard to get people to sign up for it because no one was wanting to admit that they were suffering in any way from the job, because of course that would be perceived as a weakness and comes with its own problems. So I too would like to echo my admiration for your getting behind this, and so I just wanted to ask you, are you finding it very difficult to get people to sort of kind of open up to this kind of support? And yeah.
Yeah, it can be kind of difficult. It can be rough waters. You know, you get them. A lot of times they'll reach out to you, or you'll hear an officer's not doing too great. So pull them to the office and just ask them how they're doing. Refer them to the employee assistance program and offer. It's hard, you know, when an officer tells you they want to kill themselves. It's a tough conversation. One day of training, it's just not enough. Have those conversations.
Yeah, and just so everybody's clear, I think this is right. This peer support group that you're part of, I take it right, you don't get any pay for being part of that, do you? It's
No,
just
it's all
voluntary.
volunteer-based.
Yeah.
Yep.
How long have you been working as a officer?
It'll be 2 years in April.
And what did you do before that, if you might?
I've done everything. I've
Done everything,
done a little bit
okay.
of it all.
So you must, I take it you like it enough to be committed to this cause.
Yeah, I like it a lot.
Good. I think that's it, unless anybody has other questions. Thank you very much for taking the time to come and talk to us about this important issue.
Thank you.
We didn't have any testimony from anyone else, and including KDOC, so I know that we do have representatives in the audience. Would you like to comment or not? Okay, all right. All right, we will close the hearing on this bill 2681. The next hearing is going to be on House Bill 2705, and I'll ask the reviser to brief us on that, please.
All right. Thank you again, Mr. Chairman. Jason Thompson, Revisor's Office. House Bill 2705 provides that courts are not required to appoint counsel for an indigent inmate in certain habeas corpus actions. I know there's a few non-lawyers in the room, so I should probably start there with, so these are civil actions filed after your conviction, and there's a couple different sections they can be under, and so I'm going to talk about that a little bit more here in just a second, but that's the background. Section 1 amends a criminal procedure statute, KSA 22-4506, and this is the statute relating to persons in custody after a felony conviction, and also deals with the filing of these civil actions or motions challenging that custody or their sentence, after it's been imposed. Current law provides that an indigent inmate who files a petition for a writ of habeas corpus shall be appointed counsel if the petition or motion presents substantial questions of law or triable issues of fact. That's the current law that's there in subsection A, right at the beginning of the statute. The bill specifies that this section in various places throughout will be limited to the petitions pursuant to KSA 60-1507. Those are specifically a motion attacking sentence, and that is distinguished from KSA 60-1501, which is a more general writ of habeas corpus that's challenging conditions of confinement, for example, among other things, but that's a common one. So the distinction here is if you file under, if your petition is under one action, counsel would be provided. If it's under a different one, it would not be automatic. Section 2 then goes into the habeas statutes up in 60-1503, and this is about the issuance and service of a writ of habeas corpus. So the court is finding that the prisoner should be produced to hear about their challenge to whatever they've raised in their petition. And a new subsection, E, is added. It's near the end of the bill on page 3. And it would provide that the court may, in its discretion, appoint counsel to an inmate in the custody of the secretary who is challenging the conditions of confinement pursuant to 60-1501. So you go from sort of an automatic appointment of counsel under certain circumstances to now in section 2, it's in the discretion of the court, and they may do it. And that's pretty much the peanut of the bill. I know you've got a lot of attorneys lined up, well, not a lot, but some attorneys lined up behind me to give you the ins and outs of how this works in the real world and what it would mean. So I'll be happy to answer any questions about the bill mechanics if I can.
I have a question. So let's just talk about current law. Current law is that if an inmate is challenging their sentence or their custody or their conditions of confinement, it's all governed by the same standard, which is if the court finds substantial basis and or issues of fact, then that's when the counsel gets appointed to an indigent.
Mr. Chairman, I think that's a fair summary, yes. So under current law, the language is written so that it talks about a petition or motion for writ of habeas corpus. Has found that counsel is appointed in these circumstances under either statute. That's my understanding. I think you've got some folks that'll get a little more into the details of it, but that generally is right, yeah.
So the bill that we're looking at would essentially take out of that rule the petitions attacking conditions of confinement, and in those instances simply give the district courts discretion without parameters.
Mr. Chairman, I think the goal of the changes in Section 1 is to make it not automatic unless it's a motion attacking sentence,
Right.
under 60-1507. And then the change in Section 2 is to make it in the discretion of the court for just a general challenging condition of confinement, anything that's not a motion attacking sentence. So yes, that
About attacking custody, just
I think those are probably under.
that would be part of the sentence.
I think those are under the 1501 challenges, but obviously there's some overlap sometimes, so I don't want to say, yes, I don't know enough to say for sure, but the folks behind us who actually do these motions can tell you a little bit more about the limitations, I guess, of the 1507 motions, and the broader aspect of the 1501 motions, because I understand that's the big difference.
Yes, Representative Carmichael.
Thank you. Thank you, Mr. Chair, and I do appreciate the questions of the revisor, and I'm going to display my ignorance here. At a very basic level, can you explain to me what the difference is between habeas under 60-1501 versus the 60-1507s that I saw a lot of when I was much younger?
So, Mr. Chairman, just a very basic level, and like I said, you're about to hear a lot more detail here in just a moment. 60-1507 is just a motion attacking sentence, and generally it's saying that the sentence is incorrect. My guideline sentence wasn't calculated correctly. My sentence is unconstitutional, you know, the sort of thing directly attacking the sentence itself. 1501s tend to do more with conditions of confinement, or ineffective assistance of counsel is another big one. So those are kind of the two buckets I would associate with them as a general practitioner myself, so.
Seeing no further questions for the revisor, we'll move on to the hearing. And I believe the first proponent conferee is Natasha Carter from the Department of Corrections. Good afternoon. Welcome to committee.
Chairman, members of the committee, I am Natasha Carter, Chief Legal Counsel for the Kansas Department of Corrections. Thank you for allowing time for me to submit testimony on House Bill 2705 on behalf of the department. House Bill 2705 is a bill that returns discretion to the district courts, which will result in increased efficiency and less potential waste of taxpayer dollars on often repetitive and meritless claims. First, I think it will be helpful to clarify what this bill does not do. This bill is unrelated to representation for criminal defendants, and it does not aim to deny counsel for incarcerated individuals. The vast majority of 1501 cases defended by the department involve disciplinary appeals, housing placement, and privileges. By and large, these cases are not involving major civil rights issues. Regardless of earlier case law, for decades, courts used discretion to appoint counsel in 1501 cases against the Kansas Department of Corrections. It was not until the decision by the Kansas Supreme Court in Denny v. Norwood that without any consideration for the case or its merits, courts began appointing counsel when a writ issues. Even in federal civil rights cases filed by incarcerated individuals, courts are given discretion on when or if to appoint counsel. The fact is, the standard for issuing an initial writ in Kansas is low in practice. The statute requires a writ to issue when an inmate may be entitled to relief. Some of the issues that we've seen as a department as a result of automatic appointment of counsel now when a writ issues are stalled cases. These cases are designed, they do not follow normal Chapter 60 procedures like you would see in normal Chapter 60 litigation. They're supposed to be decided quickly, summarily. We have seen stalled cases where writ issues, attorneys get appointed, and it just takes a long time to get rid of cases that didn't used to take that much time. Increased numbers. We've seen at least 85 cases appointed counsel since the Denny decision. That is not an exact number because we don't have case management software. That's just what I was able to pull in the last few days. We've seen a waste of resources in cases that aren't viable or are frivolous. And an example, that doesn't mean that every case is frivolous. It just means a lot of cases that we see are not viable from the beginning because for example, they did not exhaust administrative remedies as provided by Kansas law. They were out of time when they filed it, or they seek improper remedies such as money damages, which are not available under a habeas petition. And finally, we've seen more than one instance where a resident has been allowed to fire counsel and be appointed different counsel in the same case. As one example, we have an extremely litigious resident in the Kansas Department of Correction who has fired his counsel 5 times in the district court level and been reappointed counsel. And these are over disciplinary appeals. You know, I had a sheet up on my cell window and I want to dispute that DR appeal. So we're spending years litigating these cases. And these aren't major civil rights cases. These are, everyday disciplinary issues. We ask that you support this bill and give discretion to the district court in making appointment of counsel decision in civil 1501 cases. Mr. Chairman, members of the committee, thank you for the opportunity to speak. I'd be happy to stand for questions as appropriate.
Questions from the committee? Representative Mosley, yeah.
Thank you very much for your testimony, and thank you for being here. I'm not a lawyer. I'm not going to pretend to be a lawyer. I've only been to Dick's Wolf School of Law. So my question for you is, I noticed on this bill that it was requested by ks.gov, but it does not include bids, which seems like there's statutes that will impact their work. Did you guys consult with the Board of Indigent Defense at all when drafting or requesting this bill?
Did not.
Okay, and then also Mr. Chairman, may I ask one more question? Oh, thank you. That's very kind of you. My question for you is, this seems to that it may potentially only impact poor people because a person who is wealthy enough to get an attorney would just hire like an attorney. Is this a bill that will only impact people who are socially, economically depressed?
Well, Representative, thank you for the question. I think the answer to the question is, I think it affects the entire resident population the same, regardless of their economic status, and it doesn't deprive them of representation. It just gives the district court discretion to make that decision on a case-by-case basis, which is how it was for decades.
Representative Carmichael.
Thank you, Mr. Chair. I appreciate your patience, but following up on Representative Mosley's question, we know that a very high percentage of the people who are in DOC custody are indigent. And so where they get their lawyers is typically from the Board of Indigent Defense Services. But the gravamen of her question, I think, is that people who are in DOC custody who, for whatever reason, are actually able to afford a lawyer, they will get representation in 1501 proceedings. But those who do not have the money to hire a lawyer, then they might get representation. Is that fair?
Sure, they might get representation based on the type of claim they file.
Okay. I think that's not the way we should treat the Great Writ, but we can take that up later. Thank you.
Right. Well, I'd just point out that the law in the United States and Kansas is generally that criminal defendants in their criminal cases are indigents are entitled to representation. But we're talking here about civil actions, and the law has, generally viewed that as something within the court's discretion.
We've been down this road in some previous legislation. This is not our first glance at this. Thank you, Mr.
I'm sure it's not. And it won't be the last, I suspect.
I agree with that.
Right. Representative Barrett.
Thank you, Mr. Chair. Thank you for your testimony. Just out of curiosity, do you know what the surrounding states do when it comes to this process? Is it automatic or is it at the court's discretion?
My understanding is at the court's discretion, it's that way in federal court. There are not, an incarcerated individual cannot go file a civil rights claim in federal court and automatically get appointed counsel, right? It's at the court's discretion.
Can I have one more question, Mr. Chair?
Yes, please.
Right, thank you. And then, so my assumption is when at the district court's discretion, so I'm guessing this will be the district court that's where that prison is located. How's that filing, either way, the current process or how it changes, how's that filing made? Do they do the complaint through KDOC and they send that to the district court, or how does the process work?
Thank you for the question. Representative, are you asking how they file a petition?
Yeah, how does that process? Does it go through KDOC, which is sent to the court, or?
No, they file it directly with the court, and then we, if the court issues a writ, we'll be ordered to respond, and that's how we find out about it.
Representative James.
Thank you, Mr. Chair. You had stated that, if I didn't misunderstand you, that it was the court's discretion for years, decades, you said. Why did it change?
Thank you for the question, Representative. There has, probably hear after me that there's earlier case law interpreting the 1501 statutes. The change in practice was a Kansas Supreme Court case in 2022 called Denny v. Norwood that says if the court issues a writ, they must appoint counsel. Before that case, and it took a little while for courts and judges to figure out that they were going to have to appoint counsel, so it wasn't immediately effective. But before that case, we didn't see a whole lot of appointment of counsel. There was some, because there are always going to be some cases that need appointment of counsel. But before that case, it was not mandatory, I guess I'll say.
I have a follow-up. You said if the court issues a writ, what does that mean in practical terms, and what are they finding if they do that?
Well, theoretically, under the statute, just theoretically, it means that the resident may be entitled to some relief. That's been interpreted, it's kind of a two-step process, at least in practice. A resident files a petition, the court's supposed to screen it, and if they think that the resident may be entitled to relief, they have to issue a writ. Now they have to appoint counsel.
Stop you there. So you say they issue a writ. What?
It's just an order that...
I understand it's an order, but you're saying and now there's an automatic appointment of counsel that goes. In the past, what would happen when they issued the writ?
The history was that the court, these petitions are not always easy to understand. They're filed by pro se residents. And the court cannot always determine, I believe, from the face of the petition whether relief is warranted. So they would issue a writ, order the department to respond. We respond, we litigate that case, and the court can then tell from the evidence and the filings of the parties whether relief is warranted. Case law interprets that to be shocking and intolerable conduct. But go ahead.
It sounds to me like you're saying that it first does a look-see, and if it finds that this is, statute of limitations, whatever, it's completely without merits, the court dismisses the case.
That's what's supposed to happen, but that in practice is not what happens.
And then but if the court finds that there may be merit to it, that's when the writ issues, is that right?
Correct.
And that just means the case continues?
Correct.
Okay, thank you. We'll come back to you. Representative Mosley.
Thank you, Mr. Chairman. Help me understand. So there's the potential for an inmate to make a complaint against KDOC, correct?
Sure.
In this situation, and now KDOC is here to take away one of the ways that they're able to get access to counsel. Am I understanding that correctly, or am I misinterpreting this?
Thank you for the question, Representative. No, our desire is not to take away access to counsel. It is to return discretion to the district court so that the district court can make the decision on whether a case warrants counsel.
Representative Carmichael.
Thank you, Mr. Chair. How many 1501 petitions a year does the Kansas Department of Corrections see system-wide?
We don't have case management software at this time, but I did go back to that 2022 date, or I tried, and pulled cases that have been appointed counsel. That was the easiest way for me to check. And I found at least 85 cases. Now, that's going to be only the cases that got appealed, which means we had many more than that did not get appealed.
So if that's a period of 4 years, a little over 20 cases a year we're talking about here.
I would say it's more than 20 years, or 20 cases, but that's what I was able to find.
Okay, help me with my math.
Sure.
How many?
What I was trying to say was that is not all of the cases. That's what I could find in the past few days.
But I can only base my decisions on the facts and information before me, so the best you could say is a little over 20 cases a year.
Currently, that's the number I have, yes.
Okay, and how much does it cost to defend, or how much does it cost for the appointed counsel for each of these cases?
I don't have that information right now.
Thank you.
If I understood your testimony, it was that you were able to find those 85 cases because they were the appeal cases?
Some appeal cases, some district court cases. Some of those district court cases did not appeal their dismissal.
And is a case considered one that, like if it's litigated in the district court, then I understand if it goes to appeal, there's more counsel appointed. Are those two cases or one case?
Usually it's separate counsel that's appointed, and almost in every case that they appeal, they file a petition for review. And sometimes these petition for reviews are on exhaustion of administrative remedies, which is a requirement under Kansas law.
Thank you. Representative James.
Thank you, Mr. Chair. So help me out. The district courts have the ability to dismiss a case or go forth with it. What would be some of the cases, why would be some of the reasons why they would dismiss a case? Versus the past, you said.
Thank you for the question, Your Honor. We don't always see all the cases that get dismissed because we don't find out about a case unless it gets issued, but some of the ones that I have seen, it would be exhaustion if they catch it early. They didn't file it within 30 days, which is a requirement under the statute. Doesn't allege shocking or intolerable conduct. But more often than not, what we see is the court doesn't really screen the case, they just issue a writ.
Thank you, Mr. Chair.
Seeing no further questions, thank you. We'll now move on to opponent testimony. Kristen Patty, is it? Is that the right pronunciation? Written only, okay. Ann Sagan from BIDS.
Thank you, Chairman Lewis, Vice Chair Resmond, members of the committee. I'm Ann Sagan. I'm the Executive Director of the Board of Indigent Defense Services, or BIDS, which is the public defender agency for the state of Kansas. I appear before you today in strong opposition to HB 2705, which would alter the statutes that govern our agency, would strip Kansans who are in poverty of their right to counsel to assist them with credible claims of serious mistreatment and abuse in Kansas prisons. When a person who is incarcerated in prison in Kansas is abused to the extent that they are subject to shocking and intolerable conduct or continuing mistreatment that would violate the constitutions of the United States of America or the state of Kansas, they can ask the courts for help to stop the abuse. This is called a writ of habeas corpus, and we often refer to it by statute number 1501. These are not cases seeking money from the state. Money damages are not available in habeas corpus proceedings. What the prisoner is asking the courts for is help to make the abuse or misconduct or lack of medical treatment stop. That is all. Since 1969, our statutes have required that every Kansan who is in prison in our state has the right to counsel to be appointed to assist them in a case seeking a writ of habeas corpus under 1501, if they are too poor to afford a lawyer, and even then, only under certain circumstances that are very narrow. The person in prison must show the following. First, under Kansas case law, they must show that their complaint involves shocking and intolerable conduct or continuing mistreatment that would violate the United States Constitution or the Constitution of the state of Kansas. If they can't show that, their request for a writ can be summarily dismissed. That's a threshold question. They also must show that there is evidence that the case is not frivolous. Our statutes require that they must show that their claims raise substantial legal questions or factual issues. And finally, number 3, a court must determine that because of their poverty, they are unable to afford to hire their own lawyer to assist with a writ of habeas corpus. The language establishing that every Kansan has this right has been in our statutes since 1969, virtually unchanged. This bill will strip Kansans of that right by making appointment of counsel wholly discretionary, meaning no matter the severity of the claim, no matter how credible, no matter if they meet all 3 of those thresholds, there would no longer be a requirement that counsel is appointed to assist them. The cases covered by this bill are few and far between. When they are brought, it is usually private appointed counsel, not BIDS attorneys, that take the case. BIDS simply pays the private counsel for the representation just like we do with appointed attorneys in criminal cases. In fiscal year 2025, for example, our agency paid vouchers to private counsel to pay for the representation for 5 people in Kansas under the habeas corpus statute 60-1501. To put this in perspective, BIDS represents defendants in approximately 26,000 cases every year. Representing prisoners in habeas corpus actions under 60-1501 is a small fraction of what we do as an agency, yet these are important cases. While most KDOC employees uphold their duty to safeguard those in custody, and I do want to point out, I am very appreciative of Mr. Weingartner's presentation today, and I have been inside most Kansas prisons and federal facilities, and I can say very difficult places to work, and I respect that he came here and shared his story with you today. Unfortunately, there are KDOC employees who do not uphold their duty, and in those instances, the right to counsel to help those who are abused in prison is crucial. Sadly, it was just 2012 when the U.S. Department of Justice, supported by the United States Attorney for the District of Kansas, investigated Topeka Correctional Facility, also known as TCF, which is Kansas's all-female prison here in Shawnee County that's under the jurisdiction of the Kansas Department of Corrections, and found that KDOC failed to protect women prisoners from widespread sexual abuse and misconduct by correctional staff in violation of their constitutional rights. Further, in 2007, a prison guard employed by KDOC forced women prisoners to have sex with him, including one woman who became pregnant after he raped her. He then pressured her to take an abortion pill and had another prisoner stomp on her stomach to induce a miscarriage so that his abuse would not be uncovered. To further intimidate her, she said he told her, "Who's going to believe you? You're an inmate." Unfortunately, abusive and neglectful actions have happened even in recent years. In 2023, it was reported that 2 KDOC employees at TCF were fired and 6 were disciplined after a woman who was imprisoned injured herself by falling and was denied medical treatment twice. She then spent 2 hours crawling back to her cell because she was unable to walk. It was also reported that prison staff called her fat and lazy, and that one officer allegedly patted her own knee and said, "Come on, you can do it," while watching her crawl across the ground. It is essential to have the assistance of counsel to help prisoners in poverty in Kansas bring serious and non-frivolous claims of abuse and misconduct. How can we expect an abused and intimidated person in custody on her own without the help of a lawyer to have the ability to bring an abuser to justice and stop systemic harm to women prisoners? Kansas lawmakers have already answered this question. Our statutes in Kansas have, for 57 years, recognized the importance of the role that BIDS plays in providing counsel to Kansans seeking a writ of habeas corpus. All people in Kansas, whether they are rich or poor, should be able to go to court with the assistance of an attorney when they are being seriously mistreated or abused in prison. The fact that this bill, which removes counsel from prisoners seeking help from the courts, was requested by the Kansas Department of Corrections, the same state agency that is tasked with safeguarding the health and safety of every Kansan in state prison, is troubling to say the least. Part of our agency's statutory obligation and our mission is to provide counsel in the rare circumstances where a court finds that the allegations of mistreatment or neglect in prison are non-frivolous and are serious. I oppose any effort by the Department of Corrections to diminish this important statutory right held by all Kansans. I would also like to point out, just in response to Ms. Carter's note about Denny v. Norwood and as some sort of watershed case that made appointment automatic, that's simply not the case. If you look at Denny v. Norwood at 173, for example, the court reiterates that there is this threshold question to get a writ, that it must allege shocking and intolerable conduct or continuing mistreatment of a constitutional stature. And then it says that under the statute, the court must appoint counsel to assist an indigent inmate, provided that the district court must appoint counsel who files a habeas petition that presents substantial questions of law or triable issue of fact. So that's exactly the same as the statute's been since 1969. There is not a significant change here, and there hasn't been a watershed of new cases either. In fact, last week, KDOC asked a KORA request from our agency about the number of cases since 2022 that BIDS has represented. And our response was that there were 35 60-1501 cases between March 11th, 2022 and now that we paid invoices on as BIDS. And we gave that number to them. They also ask, and they know, in 2023, they did a similar KORA request, asking about the number of cases under 60-1505 between July 1, 2018 and May 18th, 2023, when they made their request. And the number of cases in that entire span was 58 that we paid vouchers on to private counsel, which is about 10 or 11 a year. And if you think about 35 in the last 4 years, that's kind of like 8.75 cases a year. So in fact, the number of cases has gone down since 2022. So in terms of this statute, which affects BIDS and BIDS' ability to represent defendants, we have not seen an uptick in cases since 2022, and I think that's because it didn't actually change the law, it just reiterated it. I'm happy to answer any questions.
Thank you for that. We'll take questions with this now rather than wait for all the opponents to testify. So, Representative Barrett.
Thank you, Mr. Chair. Thank you for your testimony. So I'll just ask the same question I asked one of the proponents. Do you know what surrounding states are doing in reference to? Is it at the judge's discretion or is it automatic? What do you, I mean, do you know what other states are doing?
I don't know what other states are doing. We'd be happy to look into that, but I will say it's not automatic here in Kansas. There are threshold questions that have to be met, and there is not automatic appointment of counsel.
All right, thank you. Thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chair. Ms. Sagan, I appreciate you doing that research to get us some accurate numbers on the extent of this alleged problem. I was looking at the testimony of Kristen Patty, who is one of our written-only opponents, and she talks about people being in what she describes as administrative segregation. I think I know what it is, but can you tell us what administrative seg is?
Yeah, administrative segregation, is usually solitary confinement. And in the times that I've visited clients who are in administrative segregation is one of the most shocking and difficult parts about being a public defender, because they are areas of the prison, which I'm sure anyone who works in a prison would agree, they are some of the saddest places probably here on earth in some ways, people who are totally segregated out.
I met clients in administrative seg in 1979, 80, 81, and it was the same thing then. But in her testimony, Ms. Patty describes 3 specific cases that involved a Butler County judge who I've appeared in front of. In one case, 1,134 days in administrative seg before the court could intervene, and that was after the district court judge had dismissed the claim. Another instance of a total of 1,858 days, not quite 6 years in administrative seg. Again, court dismissed it, district court, the appellate court reversed. And finally, another instance that has to do with discrimination against someone of the Jewish faith. My question is, are these things still going on? Are there judges out there that are denying people even the opportunity to be heard when they've been in the hole for nearly 6 years?
You know, I don't know the exact circumstances. I have the testimony that Kristen Patty submitted. I don't know the exact circumstances of those cases and whether those cases are resolved or if there are others like them. I certainly hope that if there are people who need relief in Kansas, that they are being heard by the courts, and I certainly hope that if they can't afford an attorney, that they are given one to assist them.
Thank you. Mr. Chair, I'll get with the research to get a hold of these 3 cases to see if they are in fact what Ms. Patty represents. Thank you.
Representative Mosley.
Thank you, Mr. Chairman, and thank you very much for your testimony. This bill is very alarming to me just because inmates deserve, especially inmates who are poor, deserve some type of place that they can go to. Can you give some examples of some of the most common reasons why someone would want to file and require your services?
So we didn't prepare kind of like a going through our cases to see what the actually numerically most common thing is. So I'm just going to say this from a practitioner, and I didn't do 60-1501 cases, so I can't, but I will say a lot of inmates have issues with medical care. So that might be something, but I don't know. And, that's probably something that somebody else who actually works in the 60-1501 space could answer. But I do know that there have been, reports from, I was just recently reading some complaints about medical care at KDOC. So, I don't know, but that's something that my clients have always complained about.
Thank you.
Seeing no further questions, we'll move on to the next conferee, which is Mr. Molino. I got the vowel on the end wrong. It's Mr. Molina.
Same thing. It's been called worse.
All right. Welcome to committee.
I appreciate the opportunity to present in front of the corrections. It's been a number of years since I've been in front of this committee, so thank you again. Joe Molina with the Kansas Bar Association. I just wanted to make 2 quick points when we talk about House Bill 2705. We've heard about the constitutional concerns from both sides, and those are significant. But when the KBA looked at this bill, something that we wanted to make sure you were aware of is the judicial efficiency point of view. We've heard from the proponents that this would help judicial efficiency. I don't think it will. The cases don't go away just because you don't get appointed a lawyer, right? You can still file pro se. And as we started this discussion and the revisor's office was explaining this bill, it became very apparent that we actually, among ourselves, have difficulty understanding exactly what's happening between 501s and 507s and habeas bills regarding both aspects of what's in 2705, us here. And now you would take a lawyer away from an indigent person trying to navigate this system. All you create is judicial efficiency, right? They're not going to be able to file things on time because if we can't figure it out here, they're not going to be able to figure it out there. So that's why we want to make sure they have counsel. So the court system can act in a very efficient manner, the most efficient it can be in these circumstances. Sometimes it's not. Sometimes it's just not because of the case and the facts and the clients and the adversarial system. But that's the system we all signed up. That's a system we agreed to. And sometimes the Constitution is hard. Sometimes the Constitution is expensive. Sometimes the Constitution takes a little bit of time. I just think the KBA wants to make sure that the committee is aware of that. We want to be efficient, right? We want to be able to look at these constitutional claims, provide the best resources and services we can, and then move down the line. And I don't think this bill actually helps that. I think it hinders that a little bit. But with that, I'm happy to stand for questions. Anyone wants to meet afterwards, I'm happy to discuss then as well.
Any questions for Mr. Molina? I guess I have one. So, as I understand the nut of this bill is it pertains to cases where they're attacking the custodial conditions mainly.
That's my understanding. Yeah.
And that would take the bill would take those cases out of the rubric that has been applied to all cases, which is substantial issue of fact or law. Where that would be the condition or the for appointment of counsel, and in the custodial cases, it would give the judge's discretion.
Yes.
Right. So it seems to me that if we are hesitant to do that, we're essentially saying we don't trust the judges to have that kind of discretion.
That's not what I'm saying. I
Well,
trust
but
judges
but
immensely.
that's, I know you're not saying that, but effectively that's what the bill is saying, is it not?
First of all, no, I don't think so. I just think
Explain,
it keeps
explain
the,
why I'm wrong, if you could.
well, one reason it keeps the status quo of everybody getting a lawyer if they're indigent, right? The KBA's point of view is if you take that away and you make it discretionary, right? It does not, the case doesn't go away. The inmate still has that claim. That inmate will still file their claim pro se, and that process will be much less efficient than if they had a lawyer helping them navigate through the system.
Right.
That's what we're saying.
I appreciate that. But we're essentially saying the judges sitting there can't make those kind of assessments. For instance, decide if you have discretion as a judge, you could say, well, this case is going to go on pro se and it's going to be difficult. I mean, if I were sitting there, I would say to myself, would counsel help me or not? And if they would, I would appoint counsel, and if they wouldn't, I wouldn't. So, I mean, it's essentially, and sometimes the law does that, and it says, you know, in these circumstances, we don't want to give carte blanche discretion to the judges, and I'm just pointing out that that's sort of what we're saying here.
Oh, I would agree that one point of view. I work for a lawyer, so I always think we should appoint lawyers.
I get it. I understand. You have an interest group to protect, and I appreciate that.
Thank you, sir.
Especially since I'm a member of the bar and you're protecting my own interest.
Whatever we can.
Thank you.
Thank you, sir.
Yeah. Representative Schlingensieben.
So do I see this correctly, that this bill is motivated by a litigious individual who's constantly firing attorneys and is making the KDOC attorneys have to work overtime? And for that, we risk depriving people of currently existing rights. I'm just curious what's motivating this, because it seems like it's a pretty weighty decision to take away the opportunity of people to have counsel, especially indigent, in order to save the department some legal fees. I mean, am I misunderstanding this? Because it's what it sounds like to me. It sounds like there's a good here that's being placed at risk for a question of efficiency, possibly financial liabilities, and that seems like not a very good trade-off to me.
We'll have further discussion on this when we work the bill. Any further questions for Mr. Molino? All right. We have now, is there someone on WebEx, Ellen Johnson? Okay. Then we'll now hear from Ms. Johnson. She's also an opponent.
Can you hear me? I am muted. Okay, Chair, I'm not muted. So as my written testimony, and out of my written testimony, I'd like to first bring attention to the two elements that most impact a resident's ability to represent themselves in court, regardless of what they're suing for, whether it's attacking their conditions of confinement. And the first of that is the confiscation and destruction of legal paperwork or any other type of property an inmate has. I did send you privately a letter where someone is talking about when he was placed in close observation. So the important part of this letter is on page 2. He's referring to as he says, he threw away all my personal property. My books my family sent me, my Bibles, my shoes, my map, all my paperwork, letters from loved ones, photos, my address book with my loved ones, phone numbers. Paperwork frequently refers to legal paperwork. And this is not an uncommon situation that residents in KDOC simply have everything taken from them, destroyed, and they don't get it. When they're moved to segregation or placed under close observation, it's very, very common. And the second issue that you can pull out of my written testimony is there's a problem with occasionally the Department of Corrections mailroom will intercept an appeal to the SOC, and it's the resident, telling them that this isn't allowed, even when it's very, very loud. I know of 2 instances in which this happened, and I know of 2 of so, and I know of another problem that we have with this, which is the DOC will provide the inmate wishing to appeal to the SOC with the wrong address. There's one resident I know that both of these things happen to, and 2 other residents I know of. One got the wrong address, and one had his mail confiscated and returned. So that's very important, and that affects any legal issue. So to elaborate a little bit further, prisoners who wish to appeal their conditions of confinement will met with roadblocks and red herrings every step of the way. Conditions of confinement in Kansas further violate the Constitution in many ways, and over and over again, lack of access to the courts and these roadblocks extend their life. They have difficulty achieving standing in the first place. So, it's to hear that proponents say that these are not major civil rights issues. These are everyday issues. We would rephrase that to say that every day these are major civil rights issues. Now, oftentimes when a prisoner does wait his appeal to the SOC, simply be moved to another facility so that he no longer has standing in court. So it doesn't surprise me that a lot of the filings we are seeing in court might be intelligently 40% residents in these facilities have mental illness. So I don't think that we really need to deny them attorneys, and I don't think that judges really need this discretion. Oftentimes, when prisoners do wish to appeal conditions of confinement, seek redress, other issues, and very real consequences of retaliation are bound. And that includes housing an inmate with another inmate who is a known threat. That means they know that person will severely injure them or kill them. This has happened in multiple instances when prisoners are fighting and not backing down about their conditions of confinement. So, frankly, the lack of access to courts and these barriers, the DOC has in fact fallen into a deplorable state of non-compliance with statutes, with the Constitution, and civil rights. President, state clear and present threat to public health and safety. Enacting this law will allow the DOC to make conditions which may be at odds with as statute, excuse me, or even the Constitution. The consequences will be even should we prevent prisoners from obtaining appointed counsel. Avoided. Eventually, someone with money will go on, pay their loved ones legal fees, and increase a little lot harder. But the longer the DOC has been released, this is costly to the public, it's costly to the state, and this will be costly to everyone except to everyone. So we see a much swifter solution in simply appointing counsel, reaching a judgment, than a full lawsuit and no solution. These problems snowball, they become systemic, they remain unaddressed, and I use the committee member has, what do other states do? In other states, when they access to counsel, what happens is basically really major lawsuits. So you get hit a lot harder, and then eventually you get slammed. That's what happens.
Ms. Johnson, if you could just wrap up, and then we'll ask
All
questions.
right. Pretty much done with that. Yeah.
Okay, well, thank you.
Thank you.
Do we have any questions for Ms. Johnson? Seeing none, we will thank you very much for coming in via WebEx today, Ms. Johnson. We will go on, and I believe there's no one else that wants to talk to the bill in the audience. We will close this hearing. So, committee, I wanted to discuss one of the bills we heard yesterday. This was brought to us by the KDOC. It had to do with setting parameters on forms, pre-sentence reports, and that sort of thing. I guess I would say this, my sense of the committee, and I don't want to presume things, but my sense is that we generally supported that bill. There has been a wrinkle, though, and it has really nothing to do with the merits of the bill. It has to do with issue that has been percolating for some time among revisers and others about whether when the legislature uses the word shall, we mean mandatory, it shall happen, or we, in some instances, really mean that the court or whoever we're telling to do something has discretion. And if you look at the bill, there were some changes in the name, from shall to must, and there was concern expressed about whether or not if we did that, we were suggesting when we use shall in other instances, we really don't mean shall. So you begin to see the problems that this might cause for not this particular bill, but others. So I just want you to be aware of that, and I know that some of us on the committee are talking to the revisers about how that might be dealt with. So that's, I was planning to work that bill today, but we're not going to do that. Any questions about that? And so, what shall we do? So yeah, we have, I don't have it in front of me, but we have several more bills to hear in the next several days. We passed the bill out yesterday by consent, so right now we don't have anything more to do, and I'll adjourn the meeting until tomorrow. Thank you.